Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Wildy, Simmonds and Hill Publishing. It's on wills. It's a very important book. It's part of their Practitioner Guide series, and this is the Practitioner Guide to Wills. It's now in a 5th edition, and there's a CD-ROM. It's big to go with it. It's being written by Lesley King, Keith Biggs and Peter Gausden, and the consulting editor is Meryl Thomas. This is the book here. Let's have a look at it first of all. It's a hardback, very much in the house style of Wildy. On the back there's some blurb which I shall refer to in a minute. It's the 5th edition that I'm talking about here. We've got at the back, let me just start backwards, we've got an index which you can see there, and it's by page numbering. It's not a particularly big index, but it's quite helpful. You should be able to find what you're looking for quite easily. And then you see the index is marked there. Then after that you've got various appendices at the back. There are 3 in fact. If I go to the front of the book, you can see the CD, which is there. And then what you've got in addition to that is there's the front page. And then after that you get a very useful preface, which says, the 5th edition, as with its predecessors, is intended to provide a wide-ranging guide to the drafting of wills, in addition to the selection of precedents and specimen wills which are included, and that's one of the reasons you've got the CD, which I think is very helpful. Do read the preface at the beginning, because that sets the scene very nicely for the book. Then you've got the structure, the contents of the book there, and then you can just run through. You can see I'm running through quite quickly. With the various chapter headings. See again there, and then quite a large number, still moving forward. There we go. A lot of very detailed information here. Things, for instance, there's things such as perpetuities and accumulations, construction, inheritance, taxes covered, capital gains tax, all these very important taxes, settlements. And then you get the 3 appendices at the back. Appendix 1 is complete wills and miscellaneous precedents. A2, that's Appendix 2, the nil rate bound discretionary trusts. And Appendix 3, temporary changes to the Wills Act of 1837, Section 9, to allow remote witnessing, which of course is all part of a more modern approach. Then there's a table of precedents, which I think you'll find extremely helpful all the way through. Because obviously this is a very technical book. Although it's a practitioner guide, I think it would be very helpful for anybody who is interested in knowing how to create proper wills. You can see the precedents run through quite substantially. Again, you get appendix at the back, and then you've got a table of cases. And there are not too many cases, but there are a few. Usual suspects are there, I hasten to add. Then the statutes, of course, it is statute based to a certain extent. Then after that you've got the statutory instruments. Then you've got non-UK materials, as it's now being called. This covers the Code Civil or Civil Code in France, conventions, directives and so forth. Then you've got table of codes and guidance. Again, quite helpful, I think, mainly looking at what the revenue does, which I think is probably the most important area for many people, plus various other guidelines, including the Solicitor's Regulatory Authority. Then you start Chapter 1, Introduction, which says, before drafting a client's will, the will drafter must inquire into all the testator's circumstances, including their family, assets and liabilities. You see the onus is fairly substantial. You can see the book runs through. There are no footnotes as such at all in the book, but you do have paragraph numbering. You can see the numbering there on the sides, and you can see how it's structured. All in all, it's an important book. It runs to some 550 odd pages, so it's a substantial book, and like all books, I'm afraid, it's expanding with all of the things that are happening. But in essence, what do I say about this? Well, I say this. It's an ideal companion for the busy wills practitioner. Now, of course, in a 5th edition by Lesley King, Keith Biggs and Peter Gausden. And Wildy are, I think, to be thanked as usual for their excellent short guides that they produce for practitioners, because they do help, and I believe that a lot of this will assist and appeal to the wider readership, that's lay and professional people together, because although I found this a very technical book, I do find it of great help to, I suspect, to people who haven't got that much knowledge, and I'm not exactly an expert in wills myself. This is more something a solicitor will do. But I think we're most happy and lucky to have the services of Meryl Thomas as the consulting editor for this new 5th edition. What's happened here is the guide has been fully revised and updated for 2023. And obviously, as a practitioner's guide, it offers us a practical and comprehensive reference source for all those who are concerned with drafting and interpreting wills and giving effect to their provisions. Now, the matters that are covered, which are listed here on the back, I'm just going to run through because it's useful in case, it depends on what you're looking for. But what you've got here are the following. What are the requirements for the virtual witnessing of wills executed during the COVID-19 pandemic? Good question, because obviously things had to change during that particular period of lockdown. What can be done to help prevent a successful challenge to a will if the testator's capacity or intention might be an issue? Always an important factor, because that is where quite a lot of the litigation, of course, arises. To what extent can the terms of a will give rise to a need to register a trust with Her Majesty's or His Majesty's Revenue and Customs? What are the pitfalls if creating a will trust where it is hoped to claim inheritance tax residential nil trust rate allowances occur? That again is an important one to look at where the problems may be when you want to get some sort of help in terms of inheritance tax. And then, do nil rate band discretionary trusts still have a purpose in estate planning? Another very good point. Don't confuse estate planning with anything other than what it says. Estate planning is about looking ahead at what the financial implications are for the future. It's not trying to dodge tax, which is what some people suggest. It's not tax avoidance in that sense. It's being sensible about what happens to property over a longer period of time, bearing in mind the general common law principle, which has always been there, that we don't want to tie up land indefinitely. I'm talking specifically about land when I talk about property. And finally, the big question again, which is mentioned here, is how does the court now deal with disputes over the interpretation of wills as a result of the decision in Marley versus Rawlings and the family provision claims after the case of ILOT, which is ILOT versus Blue Cross. ILOT is an important case and one that is obviously very well known within the legal community. What we've got here, of course, in the book, in addition to those questions which are actually carefully addressed, is it looks at the extensive range of specimen clauses and model wills which are set out in the separate appendices that you've got. And of course the CD-ROM, which is right at the front here, is extremely helpful. And that, again, not all computers, of course, have access to the CD-ROM system, but at least you've got that at the moment. Again, in the future, it will all be linked directly into the internet itself. Now, with all Wildy, Simmonds and Hill publications, the book, I say, and certainly reading it, is written in a very accessible style. It's not difficult to understand after some of the really heavy works of the past, which were not easy. They were not easy books to read at all. This is good. It's a useful reference book as well for both new and experienced practitioners. And as I said, the new hardback arrived earlier this year, actually beginning of January of 2023. There's the book again, just showing it to you, side and then the back. And then I'm just going to open it in the middle. Let's have a look here. We've got conditions attached to gifts. Okay. Now, what we're talking about here is the type of gift that can be given and the conditions that go with it, and what happens if it's described or decided that in fact what is called a condition precedent is actually invalid. In other words, it's void. What then happens? And it gives you some indication about forfeiture and various other indications. And you've got a whole range of other things. You've also got quite a useful section on powers and discretionary trusts. Now, again, that is an area which is not for the, if I can put it this way, for the faint-hearted. Because when you're looking at the concepts of trusts, for the beginner, it can be quite confusing. And I say that having just done a couple of cases which have basically involved the concept of either resulting or constructive trusts. And trying to explain that to a client is not the easiest way of going about things, because it can actually be quite a complex area. And so the aim is to try and keep it as simple as possible. This book does go into detail, but I think the simplicity is there. So I'd like to thank the three authors very much indeed for what they've produced. That's Lesley, Keith and Peter, and of course to Meryl Thomas as well for her excellent contribution. But thank you mainly, of course, also must go to Wildy's for giving us these practitioner guides, which are so helpful. We're very grateful to all of you. Thank you. Bye-bye.